Hello and welcome back to Drama Investigator. Tati Westbrook is currently suing drama channel Without a Crystal Ball for defamation, and she recently responded to Without a Crystal Ball's motion to dismiss. Boy oh boy did Tati's lawyer bring the receipts, as per usual. So shout out to Emily D. Baker, a lawyer who makes YouTube videos, for always bringing through the receipts, including this opposition to defendant's motion to dismiss that we're going to investigate today. Love a smash. So before we dive into this response from Tati's lawyer, let's take a look at the drama going down on Twitter at the moment. Someone had tweeted, Laurie Ann, whose tweets threatening violence and showing KJ, said she's one of her most loyal and fierce supporters, were in Tati's response to KJ's motion to dismiss, is KJ's best friend and a paying member, also a Washington resident, seemingly cementing jurisdiction. Tati's lawyer responded, KJ said in her declaration that she does not derive income from Washington. This video shows Laurie Ann from Washington as a paid subscriber and is KJ's best friend. Does anyone else have any other examples of videos containing super chats from Laurie Ann pre-10th of the 30th, 2020? KJ also states in her declaration that Without a Crystal Ball has no employees. However, this video from 6 months ago has KJ saying that Jessie is on the payroll. Please contact us if you have any other videos or tweets wherein KJ states that she pays Jessie. Saucy, saucy. So yeah, basically throughout Tati's lawyer's response, Tati's lawyer not only mentions paid subscribers who allegedly made threats, he also includes declarations from people who were potential buyers of Tati's products who decided not to buy based on Katie's false reportings, which again backs up Tati's case that her business has been harmed. So currently Katie Joy has privated her Twitter and blocked a ton of people after going on a huge rant the other day. And honestly, what's the point? Like seriously, if you're just going to go private your account, I don't understand. Is she trying to hide from Tati's lawyer and then follow him on a fake account like he alleges? So anyway, let's break down Tati's response to Katie Paulson's motion to dismiss and expose the juiciest parts of this lawsuit. The introduction states, over the past 19 months, defendants Katie Joy Paulson and Without a Crystal Ball LLC have engaged in a course of conduct specifically aimed at harassing plaintiffs Tatiana Westbrook, James Westbrook and Halo Beauty Partners LLC through defendants' social media communications, including publishing defamatory statements about plaintiffs in at least 80 YouTube and Instagram videos, and in more than 100 postings on Twitter and other locations on the internet. This case arises out of these widespread incidences of defamation and the ongoing campaign of harassment defendants have waged against plaintiffs. Defendants filed a motion to dismiss the complaint, asserting jurisdictional, failure to join a necessary party, and failure to state a claim arguments as their basis for dismissal. In the motion, defendants attempt to distract the court from the defects in their argument by relying on inadmissible evidence and extensively reciting wholly irrelevant facts. In addition, defendants rely upon the misleading declarations of Paulson and her attorney Michael P. Brown to support defendants' jurisdictional arguments, as well as obsolete, inapplicable federal case law and California state law to support their jurisdictional and failure to state a claim arguments. Finally, defendants fail to acknowledge that their deletion of evidence, particularly YouTube videos, destroyed evidence relevant to their jurisdictional objections. The court should deny the motion to dismiss because 1. Defendants have sufficient minimum contacts with the forum through their research, published of defamatory statements in the forum, and targeted known residents of the state of Washington. 2. The court has subject matter jurisdiction over all plaintiffs' claims through diversity jurisdiction, which is not destroyed by the inclusion of DOE defendants. 3. There is no required joinder of parties under Rule 19. And 4. Plaintiff's complaint satisfies the requirements of Rule 8A2 and states claims for relief that are plausible on the face of the complaint. So here in the statement of relevant facts, it basically goes in depth about Katie digging up Tati's background and trying to expose her and her husband. It basically talks about all the defamatory statements she's made, which I believe, if I can remember correctly, Katie said that she said some of this stuff out of comedy. And it talks about, Katie investigating where Tati and James lived and how she made 80 videos about them. Further along it states, defendants' Washington viewership and plaintiffs' harm in the forum. This section basically delves into how what Katie did was harassment. Here it states, testifying that she is a Washington resident and viewed defendants' social media content about Tati, James, and Halo, including YouTube and Twitter, beginning in May 2019, showing a defendant's proclaimed follower/fan, Laurie Ann Barnhart, whose online information indicates she is a Washington resident, as one of their fiercest and loyalist fans, showing defendants defending Laurie Ann on Twitter, and showing a screenshot of defendant's computer screen containing defendant's Twitter direct messaging list, which appears to include Laurie Ann's direct messaging information. So yeah, going back to what we mentioned at the start of the video, Tati's lawyer has found out that this chick who loves Katie Samach, one of her ultimate top fans, is like people. She may have allegedly threatened Tati, and then Katie's like BFFs with her very publicly. So yeah, just another thing Tati's lawyer can use in the lawsuit against Katie. It then goes on to talk about Tati and James's residence, when Tati posts on social media, etc. Now this is where things get super saucy and shady. Tati's lawyer said, "From the beginning, defendants repeatedly claimed to know everything there was to know about plaintiffs and their business because they had researched everything and everywhere, including Tati and James's birth certificates, financial records, and business records, as well as Tati's entire Washington-based family. In fact, in the same May 2019 video referenced above, defendants flippantly questioned whether Tati's father was in the mafia because they could not find any employment records for him anywhere, despite searching every Washington-based database available to defendants. From the very first defamatory and harassing publications about plaintiffs, defendants spoke about how Tati grew up in Washington and that she is just a failed actress from Washington. The idea that defendants completely circumvented Washington sources in their research of Tati, her husband and other family members, and her business is wholly implausible, especially since defendants' own statements in May and June 2019 directly contradict that sentiment. Likewise, defendants' assertion that they did not know Tati and James were living in Washington before December 2019 is patently false. In the June 2nd, 2019 video, entitled "The Background Tati and James Don't Want You to Know," defendants indicated that they knew Tati and James's current address, but were not going to reveal it in the video. They then showed a copy of Halo's business information from Nevada's Secretary of State records, which listed Tati and James's offices of the company and showed their address in Washington. Even more revealing is the fact that defendants expressly redacted the street and city portion of Tati and James's Washington address before showing it to their viewers, meaning that defendants had a personal and physical interaction with said address and cannot claim to not have seen it. In addition, Nevada's Secretary of State records also show that another business of Tati's and James's, Tati Halo Inc., was a managing member of Halo and had a Washington address that was different from Tati and James's Washington address. Tati Halo is one of the 3 Washington corporations owned by Tati and James. All 3 were incorporated in Washington, and their business information was publicly available on Washington's Secretary of State website in late 2018 and early 2019, prior to defendants' investigation into plaintiffs in May and June 2019. At the time of their first defamatory and harassing publications, defendants knew that all 3 plaintiffs had significant Washington connections and business activities. Given defendants' goal of learning everything there was to know about Tati, in a concerted effort to harm her, it is impossible that by the June 2nd, 2019 video, defendants did not know about Tati's and James's Washington business activities or Halo's connection to Washington through Tati, James, and Tati Halo. Moreover, defendants expressly aimed their conduct at the Washington Forum because, like the defendants in Keaton, defendants circulated their defamatory content to viewers in Washington and derived income through all viewers of their content in Washington. Defendants even asked their followers, subscribers, and viewers, some of whom they knew were located in Washington, to donate money for the cost of research and obtaining the records to expose plaintiffs. Despite Paulson's assertions and her misleading declaration, defendants know that their defamatory materials have a circulation in Washington because the analytics for defendants' YouTube videos easily provides this information directly to defendants. Likewise, defendants' arguments regarding brunt of the harm also fail. First, the Ninth Circuit, relying on Keaton, expressly has rejected any requirement that the brunt of harm from defamation be felt in the forum. Second, as both the Keaton and Walden courts noted, due to the nature of the defamation tort itself, a party is harmed wherever the defamatory material is published to a third person, regardless of the party's residence. The evidence before the court demonstrates that defendants' defamatory content was published to and viewed by Washington residents. The evidence also demonstrates that Halo's reputation was injured in the view of the Washington community, and Halo lost Washington customers due to defendants' defamatory statements. Likewise, the evidence shows that Tati and James's reputation in Washington were harmed by defendants' defamatory content, and that Tati and James both experienced emotional distress in Washington as a result of the defamation. Furthermore, contrary to defendants' arguments, Halo's Nevada residency does not preclude the court from exercising personal jurisdiction over defendants as to Halo's claims. Courts consider a plaintiff's residence in the forum as a factor supporting jurisdiction, but neither domicile nor residence is the requirement. This is especially true in defamation cases where a plaintiff is harmed wherever the defamatory statements are published. Like the non-resident plaintiff in Keaton, Halo's Nevada location is immaterial to the jurisdictional inquiry because defendants' own forum-related conduct satisfies the minimum context requirements. So the rest of the lawsuit consists of all the emotional distress that this has caused Tati from Katie's behaviour, and they allege how Katie committed civil harassment. So lastly, in this section of the lawsuit, it requests to strike evidence submitted by Katie's lawyer in her motion to dismiss, and OMG, the shade is real, guys. I am cracking up by reading this. Pursuant to Local Rules CR7G and the Federal Rules of Evidence, plaintiffs object and move to strike the declaration submitted by Michael P. Brown in its entirety as it lacks personal knowledge, lacks foundation, and includes inadmissible hearsay. First, Mr. Brown's statement referencing Zillow.com in the second paragraph of his declaration is inadmissible because it lacks foundation and personal knowledge regarding plaintiffs' real estate acquisitions. Defendants used Mr. Brown's statement and the Zillow.com listing to prove that the Westbrooks did not list their Los Angeles home for sale until September 2020. However, the screenshots fail to actually identify the Westbrooks anywhere in the image. In addition, the entire statement is a hearsay, as the screenshot does not actually show a purchase of sale of the property, but instead shows that Zillow, a third-party website, shares information that has been obtained from a real estate broker. Third, Mr. Brown failed to provide any evidence that the Westbrooks lived in the house after they purchased it, which they never did. Second, the remainder of Mr. Brown's statements, which are about Glam Life Guru's social media accounts, are also inadmissible because Mr. Brown lacks the foundation and personal knowledge to attest who used the Twitter and Instagram accounts on those days. So this next part is plaintiff's opposition to defendant's request for judicial notice submitted in conjunction with defendant's motion to dismiss. Basically, it just goes into how what Katie said in her motion to dismiss is just like dumb and doesn't add up. For example, it states defendants rely upon statements purportedly containing in the Swanson complaint, but in actuality are nowhere to be found therein. So Tati and James both had declarations in this lawsuit, and in James's declaration he links Dropbox links to Katie's videos he's downloaded and re-uploaded for the judge to watch and see Katie essentially defaming him. The final parts of the lawsuit go into people's declarations that didn't buy from Tati as a result of watching Katie's videos, and Tati's husband also goes in on Katie, alleging that she lied in her motion to dismiss, where he includes a lot of examples, one of which includes here where he says, "I have reviewed Ms. Paulson's declaration submitted in conjunction with defendant's motion to dismiss. Upon review, based on my general knowledge regarding the business of social media and my specific review of Ms. Paulson's video, Ms. Paulson's declaration appears to contain several untrue statements. One of the statements that I believe to be untrue is that defendants have no employees. I personally recall viewing a video wherein Ms. Paulson states that her husband was an employee of defendants, and another video wherein her moderator Jessie Beer stated that she had the best employer ever. A screenshot I had obtained from the video containing the statement from Jessie Beer from defendant's YouTube channel is below, and here we can see that receipt where she'd said, 'I have the best employee ever.'" Saucy, saucy. So what are your thoughts on all this drama? Let me know in the comments.